our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?"
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey everybody, and welcome to the show. Today we're talking about understanding Florida land trusts. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, YouTube, and X. On all of those platforms, you can find us at the handle @INREM Podcast. That's @INREM Podcast. Also, you can go to Spotify, Apple Podcasts, or any other platform to download an audio version of the podcast so that you can listen if watching is too inconvenient. In all cases, it's free. Go there, leave us a review. We appreciate it a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is what is a special warranty deed and when should it be used? So a special warranty deed is a deed that title companies and others use to convey fee simple title to real estate to a purchaser, also called the grantee, in the warranty deed. But the word special has a connotation. So you can generally convey property to a third-party buyer by a general warranty deed or by a special warranty deed. And the significance is deals with the warranties that are being provided by the seller of the property. So in a general warranty deed, a seller is warranting good title basically from their ownership all the way back to time, that there's no title defect, no title issues, and that they are going to deliver good and clear title, subject to any, exceptions that have been either listed on the deed or agreed to by the parties. They're going to provide good title to that buyer or grantee. A special warranty deed, however, limits the warranties for just any title issues that occur at the while the grantor or the seller owns the property. So in that case, they're just saying, hey, if anything happened while I owned it, I'm going to warranty it. But anything prior to my ownership, that's on you. And I'm not providing a warranty as to that. So it limits it just to that seller's ownership. So when should it be used? Well, if you're a seller, you want to use it all the time. And if you can negotiate that as part of the terms of the purchase, then yes, negotiate a special warranty deed. So that's when it should be used, is when the seller wants to try to limit their warranty deeds. And frankly, most sellers limit their warranties. In that case, most of the time the seller is going to want to limit their warranties. And so it should be used as often as the seller can negotiate it.
All right, Sean, thank you for the legal update. Reminder, every Tuesday at 2:00 p.m., join us for the Creative Finance Collective. What is that? That is a chance for lawyers and professionals in the space of creative finance to get together and talk through issues that they're seeing, changes in the law that they're seeing, issues or fact patterns maybe that they've run into. But we're there to just talk about creative finance. There is a kind of a niche group of attorneys in the space, really throughout the country, that have devoted their practice or some of their practice to understanding the unique nature of the transaction that we call creative finance or creative financing. So make sure to join us, but it's a good opportunity for you, the listener, to ask us questions. We are there captive to you for an hour as long as we're getting questions. So if you've seen a deal or you're trying to understand the risks, the benefits, what the transaction looks like, soup to nuts from start to finish, That's what we're there to talk about and answer. And at times we're able to kind of direct you to attorneys, maybe from the state that you're coming from, that can help you more specifically with regard to your matter if you're dealing with a specific type of transaction. So make sure to join us 2 p.m. Arizona time every Tuesday. With that, we're going to get into our topic today. So today we're talking about the land trust, and specifically the Florida Land Trust. And with us to discuss that topic is our own Natalia Ouellette-Grice. Natalia, how are you? Good to see you.
Hi, good to see you, Andy and Sean.
Yeah, happy to have you. For our listeners that aren't familiar with you, you're a founding partner at LCO Law LLC. Why don't you tell our listeners about LCO Law, what you guys do and focus on?
Certainly. So we are an investor-focused law firm. My background is I ran a title company in the state of Florida for close to a decade. So I know all the ins and outs of all the creative ways in which investors bring deals and they want to close them. About half of my practice does real estate title and possession litigation. So we deal with the cleanup to get things ready to close. And the other half is with respect to asset protection for real estate investors. So land trust is one of those key asset protection tools, in addition to the estate planning, irrevocable trusts, and other types of entities that get used to isolate assets and segregate risk.
Now, you've also authored a few books. Why don't you tell us about those in your latest book?
Sure. So I've written 4 books so far. The first one was about tax deeds, came out in 2019. It's about helping real estate investors invest in Florida tax deeds. The subsequent year, I did one on for investors who are interested in investing in foreclosure sales here in the state of Florida. And I go over 3 different types of foreclosures. The typical mortgage, HOA, and then lien foreclosures, because that happens as well. Counties like to foreclose. The subsequent one was about managing a business and how to run it properly. I see a lot of real estate investors out there who have started up all these businesses, but really don't know the ins and outs of running the mechanics of it. So it was more instrumental for that. And the fourth one was about managing Florida rentals effectively, organizing the structure of a lease agreement and the things that are missing and why they should be there, and presenting little, I'd say like little scenarios using creative situations of tenants and their landlords and what happens and the discussions that take place and how to minimize the risk and how to optimally win in court if something does become an issue. And the one that I'm writing right now is about asset protection for real estate investors. So this is definitely one of the topics covered. I cover title, trust, and taxes. And well, the Florida Land Trust Act can address all 3.
Now, when do you expect the one you're working on now to come out?
I want it to be done by the end of the year. I'd say halfway through.
Goals. Well, Sean and I have talked about doing a book for some time now, and it won't be ready by the end of the year. So you are sticking to your goals better than others. So we understand your firm also has a podcast for small business owners called the Legacy Academy. Tell us about that.
So the Legacy Academy, I think we have about 3 seasons, covers more in depth the questions that people have with respect to, for example, investing in a tax deed property. What needs to be done to quiet the title? What's the process? Or some of the disputes that take place between landlord tenancy issues. We're going to go a little bit more heavy into it with taxes and tax issues that arise for real estate investors the rest of season 3. But yeah, it's just far more in depth, kind of like you do here with the In-Rem podcast. It's just covering a topic more deeply for the audience so that they do not get themselves into trouble.
Now, where's the best place to go? Is it an audio podcast, video, both?
So it's an audio one. You can get it on Spotify, on iTunes, all the major regular podcast places. Mm-hmm.
Very cool. All right, so today we wanted to talk about land trusts. And if you've been a watcher of this show, you know that we've talked about land trust. We've talked about land trust with a variety of guests, and including Natalia over the months and years. And what you've probably found is that there's a lot of different laws on land trust, and a lot of different states treat them differently. Some states say very little about them. Some states rely kind of on a common law understanding of them. But every state is a little bit different. We wanted to focus on Florida's land trust because they are unique. The legislature's gone out of their way to think through what that means for Floridians in that state. So, Natalia, why don't we just start here for the listener? What is a Florida land trust to you, and how does it differ?
So a Florida land trust is an absolute creature of statute. What do I say? I mean, that is something that is codified as existing because the legislature specifically decided that this is going to be a thing and it's going to work in this specific way. So that's different from common law trusts, which, it could be any sort of a relationship where somebody's acting as a fiduciary on behalf of other parties and taking care of their assets, which could be as a result of oral communications or written communications. The Florida Land Trust Act, though, designates Florida land trusts to be very, very custom and specific. And if you don't follow the statute, you're not in compliance with what a Florida land trust is.
Now, I would imagine, so when I hear something created by statute as opposed to common law, what that tells me as an attorney, the details are much more fleshed out, and the expectation on you in creating it are much more defined and reliant on your ability to follow a statutory scheme rather than some sort of common law doctrine. Is that generally the case? The statute's pretty clear on what it takes to set it up, so on and so forth?
Yes, and it's got very specific directives. So one, it has to be written. If you, for example, thought, I'll just put my name as trustee of the blah, blah, blah land trust, and you don't actually have a separate written land trust agreement, you don't have ownership via Florida land trust. And the other aspect is there has to be specific language in what conveys the asset to the land trust. And that specific language, if not met, if not included in the instrument, which could be a deed, it could be a lease, it could be a mortgagee interest, if it's not quoted, it's also not compliant with the statute.
So under common law trusts, we generally have, the creator, who is also referred to as the grantor, the settlor. We have, trustees, we have beneficiaries. Who are the parties to a land trust, a statutory land trust in Florida?
So it's very similar, right? There's got to be an entity that is creating the land trust or a person. So it can be an individual or an entity, could be an LLC, could be a human being, could be a corporation. So that's the grantor. They don't really play that big of a role with respect to the statute and what applies. Then you have the trustee. The trustee is, of course, the person or entity that manages the land trust assets, and they're the ones that hold legal title to the assets. And you've got beneficiary or beneficiaries, right? It could be more than one, which can also be an entity, a person and an entity, different combinations. And you've also got a unique party in the Florida Land Trust Act, and this is called the holder of the power of direction. So if you don't designate who gets to tell the trustee what to do, then by default, it's generally the beneficiaries, the majority of the beneficiaries who decide what the trustee can do in terms of selling or signing this lease or, that kind of thing. But you can also designate a separate holder of the power of direction. This could be a different entity or a different person that actually is the one who's got the authority to tell the trustee what to do with respect to the asset held in the trust.
Do any of these parties to the land trust have to be Florida residents to create a Florida land trust, or can somebody just say, hey, I'm from Arizona, I'm going to go see Natalia, she's going to work with me and we're going to form this Florida land trust and it'll be great, and I can start buying real estate in Florida using this land trust?
So Florida is unique with respect to this being a statutory asset protection vehicle, and Florida not having placed those kind of restrictions on who can be a trustee. Because if you look at the majority of states who do have asset protection trusts, they tend to have this very unique requirement of the trustee's got to be a resident of the state of Florida. We don't have that requirement in the Florida Land Trust Act. So you can have a trustee that is an entity or a person from any other state. You can have a beneficiary who is an entity or person from any other state. The only requirement is the Florida Land Trust Act and the way that it's receiving property comply with the statutory requirements. That's it.
And does the property that the land trust receives, does it have to be Florida real estate?
No. So Florida Land Trust can own property outside of the state of Florida. Now, of course, here's where it comes really important with having, attorneys in all of these different states where you might be investing, because depending on the state, while that state allows property to be owned by a trust, it might have specific requirements as to what needs to be disclosed if it's going to be owned by a trust, right? For example, Georgia or Arizona, they require certain declarations about the beneficiaries, which can defeat the purpose of privacy, if that's what you're seeking as part of your asset protection motive, but it doesn't defeat the
Right.
limitation of liability in a Florida Land Trust Act.
So I was going to say, what is the connection to Florida? Or is there a necessary connection to Florida other than, I guess, if you organize a Florida land trust, it's going to be governed by the laws of Florida. But if the grantor, trustee, and beneficiaries don't have to have any relationship to Florida, and the assets itself don't necessarily have to relate, is there any sort of necessary relationship, if that makes sense?
So per the statute, there's no necessary relationship. Now, of course, if you are somebody from a different state with an entity from a different state, you are going to be subjecting yourself to Florida law as to how it's interpreted. The Florida Trust Code with respect to other limitations or imposition of liability for your trustees. And if you don't have local Florida counsel that can explain this to you, you're going to be running a little blind. So it is a unique asset protection tool, but I think the Florida legislature is generally very investor friendly. And so this was just another tool in a toolbox for people that wanted to invest in real estate, and a way to encourage them to come to Florida and invest here, even if it's not necessarily just limited to Florida real property.
Is there a requirement as to the name? When I create a name for a trust, I've got I'll do a lot of estate planning trusts, and we've got a lot of leeway with the name, but again, we're not governed by statute. Does Florida law impose any sort of naming requirement on how you go about doing that?
So normally in practice, we'd put something like and you can come up with anything creative, right? Land trust. And then you do have to have that operative language quoting 689.073 of the Florida statutes. So that's where it becomes more restrictive, is that you do have to quote that specific statute. You do have to have the requisite language in order to be effectively treated as a Florida land trust. So that is not necessarily part of the name, but it's part of the conveyance.
Mm-hmm.
So under your common law trust, like Andy mentioned, we do a lot of estate planning. And so we're doing just your standard revocable trust. And our trust code in Arizona, and I'm also licensed in Wisconsin, we have a similar provision, basically says, hey, it doesn't say it exactly like this, but saying essentially the trust and the grantor settler of the trust, the creator, are basically one and the same when it's a revocable trust, meaning if the trust owes creditors funds, money, then the grantor settler owes money. And likewise, the trust remains liable for the debts and obligations of the grantor settler for their lifetime, basically. So it's essentially saying, hey, you cannot basically shield all of your assets by creating some revocable trust for your children, for example, or something like that. It doesn't work that way. It's really just a probate avoidance vehicle. Is the Florida Land Trust similar in that type of, asset protection or lack thereof?
So it's a unique hybrid. On the one hand, right, most Florida land trusts are written as revocable trusts, right? By default, trusts here are revocable unless specifically stated to be irrevocable trusts. So as we know here, we don't have self-settling trust in Florida, meaning you can't convey to a trust that's a trust to protect you against your own creditors. The Fraudulent Transfers Act still applies. So if you've got a claim here and you're moving an asset, it's a bit late to be moving assets into any sort of asset protection vehicle. that clawback provision for the Fraudulent Transfers Act is still going to apply. But on the other hand, you can define how that asset is going to be perceived for creditor purposes for the beneficiary. So the beneficiary can choose to have that beneficial interest be treated as personal property or as a real property interest. And it's how it's written into the instrument, which means that if you choose for it to be treated like your beneficial interest in that land trust, to be treated as personal property, then whatever creditor has a judgment against that beneficiary needs to proceed with like all of the requisite steps and registering with the Department of State Division of Corporations here to get a perfected lien interest on personal property. And that one's subject to 5-year statute of limitations, et cetera, to execute, get things done. As opposed to if you decide to treat it by default as a real property interest, then there still needs to be a corresponding mortgage or other sort of real estate security interest recorded to secure a lien over the real property interest of the beneficiary. But you make that choice as a beneficiary, which is unique.
Now, what about in terms of when you're setting up a Florida land trust by statute? Are you given the option under statute whether you want to make that a revocable or irrevocable trust, or is it just one or the other, or is it just one?
So you have the option. You can make a Florida land trust irrevocable, and if you are conveying property into an irrevocable instrument at that point, then it is a completely separate legal entity. You will have to go get your own tax ID for it. You will be subject to the federal taxes on trust instruments as opposed to the pass-through for a revocable. So you do have to be very mindful of the tax consequences involved in making it as a high asset protection tool irrevocable. But even if it's irrevocable, right, if you've waited so long and you have a claim here and you have a claim here and you have a lawsuit coming here and you're trying to shift it into an asset protection vehicle, it's too late. They don't care if it's irrevocable or revocable. They can claw back.
Now, do you get, or have you represented investors that don't have any relationship to Florida, aren't interested even necessarily in land in Florida, but love the treatment of the Florida laws as it relates to land trusts? So they're coming there basically just to form it and have that statute apply?
No, most come to me after they've done at least one investment in property in Florida. So they're from out of state, they may have out of state entities, but something, tickled their interest in Florida earlier on. And now they want to start acquiring real estate, not just in Florida, but out of state using that vehicle.
So when we hear land trust, we think, oh, real property. But can other assets be put into the land trust, or is it really restricted to holding title to real estate?
So it's not just for holding title to real estate. Under the Florida Land Trust Act, it's any interest in real property. And so the statute says, including a leasehold, including a mortgagee interest. So, you can own an easement in a land trust. Any sort of interest that can be broken down into that bundle of sticks that we know that are real estate interests, you can own in a land trust. Now, of course, you can't put a car in a land trust and expect it to be protected or anything that's personal property, which is something to be mindful of if, for example, you have an RV or a mobile home that you thought was real property, but it's not really real property. It's separate and distinct from, its title is passed through the DMV rather than through the real property and official records. So you've got to be careful with those, because sometimes people think things are real property that are not, but any real property interest can be held that way.
Now, let's say you hold real property that you're leasing, right? So you're the landlord. So the land trust is the landlord. Can a bank account be opened in the name of the land trust to receive rents and things like that and to pay expenses related to the property?
So usually it's the trustee that will create the bank account, right? If you have an irrevocable trust, then, at that point, it's not just a pass-through holding entity. You will want to have its own separate bank account and go to a financial institution that will actually allow opening up bank accounts for trusts. Not all of them do. But generally, it's the trustee. So whoever the trustee is the one that's going to be receiving the income from, rentals, et cetera, or from the sales proceeds, and then distributing that to the beneficiaries.
Now, how about for purposes of taxes? Is it typical as it relates to maybe just estate planning trust, where if you're doing a revocable trust, it's really kind of a pass-through? They'll look to the Social Security numbers of the grantors, or do they require like a formal EIN designation where the land trust is always going to be filing its own separate tax return?
So because it's treated in essence as a pass-through revocable trust, so long as it's revocable in nature, and the beneficiary is pretty much the entity that conveyed or person that conveyed into it, then it's going to have the same flowing considerations. So when you're paying taxes, let's say you decided, I have it in my name, I don't want to have it in my name anymore, it's foolish for me to open up all of my personal assets with this investment property, so I'm going to convey it into a land trust, and you put yourself as a beneficiary, or yourself through your regular family revocable trust, right? Which is also a revocable instrument. Then it's still going, all the income, expenses, et cetera, still going to get taxed to you at your individual level. Same thing if you were an entity and now you're the entity beneficiary, you just wanted to isolate your assets that you held in your entity. It's still going to be taxed through the entity tax ID, because the entity is the owner of the financial interests.
So if an investor client comes to you and they say, okay, I want to hold long-term rental income real estate in a land trust, number one, would you recommend a land trust? And number two, if you would recommend a land trust, how would you structure it? Who would, who would form it? Who would be the trustee? Who would be the beneficiary? Would you appoint, I forget what you called it, but the person in charge, that
Power of direction.
what to do. Mm-hmm. Yeah, the power of direction. Would you appoint that person? What would you do if somebody came to you and said, I just need to get this rental property out of my name somewhere, whether an entity, land trust? What would be your recommendation there?
So I would look overall to see what's a bag of goodies that they have in terms of assets and investments, right? If it's just one particular property, and they don't plan on acquiring any other property, this is it, this is going to be just held in the one entity, I would say maybe having it in one limited liability company is okay to do. We want to make sure that if it's in Florida, it's not a single member LLC, because you got problems there. So if you want to be the only one in control, single member, maybe go for a Florida land trust. So those are things to consider. If they, however, have more than one property, that's when we start talking about, okay, well, let's place each one in their own little cocoon, which is Florida land trusts. Because I would not want to recommend you having an LLC here, an LLC there, another LLC, another LLC. I mean, it's cost prohibitive and it's a lot to manage for most people. Whereas a land trust can have the same beneficiary as this land trust, as this land trust, and this land trust. So all the money financially, right, it's just being taken care of by one party at the bottom, the beneficiary. I would want to know how comfortable they are with who they want to be the trustee. Do they still want to appear in the official records? Do they want more anonymity? Maybe if they want anonymity, maybe it's an entity trustee. And if it's going to be an entity trustee and they want anonymity, maybe not register in the state of Florida or through a Florida LLC, because we're pretty public in showing who manages entities here. So picking a state that's a bit more private, probably better for a trustee. So those are some of the determinations that go into play with it, right? And depending on maybe their condition or their situation, they might want somebody else to be the one holding the power of authority for direction of it's going to get sold, it's going to get this and that. Maybe if they have really terrible driving habits, you want to make somebody else be the one holding the power of direction, because you're going to be a lot more likely to have lawsuits for car accidents, right? So those things are taken into account in the conversation.
Can the same entity be both the trustee and the beneficiary under a Florida land trust?
Yes. So I know what you're alluding to, right? All of us that practice trust law know this doctrine of essentially merger, which is if you're sole trustee and sole beneficiary, you don't have a trust anymore. Well, the Florida Land Trust Act disposed of that specifically just for land trusts. So you can be the only trustee and the only beneficiary under a Florida land trust without that causing the trust to not be in existence.
So what do you see as the biggest benefit or benefits to the statutorily created land trust in Florida as opposed to just your garden variety revocable living trust to hold land?
So one, it actually does provide asset protection in isolating an asset, which we can't do with standard revocable trusts, right? If I put, I'm not going to say my home because Florida has homestead protections. But let's say I put like my investment accounts and my bank accounts and this and that, and then some investment properties. That's all getting put there together. There's no asset protection for the grantor, for the person that created that.
Mm-hmm.
If you end up being in a bad car accident or boating accident or whatever other reason causes creditors to go after you, they can go after any of your assets in your revocable trust instrument, in your standard regular revocable trust instrument. But with respect to assets that you put into a Florida land trust timely, right? You didn't wait to put them in after you've got these like creditors following you. You did it before anything happened, while your record's still clean, while you don't have any issues. And you've placed it there. You've now isolated that instrument so that the legal title is under a completely separate entity. It's under a land trust. And if you're in a car accident, etc., they can't necessarily force the sale of that piece of real estate to satisfy their judgment because it's owned by a separate legal entity. They have to wait, kind of like a limited liability company, for distributions, cash to come out of that. But it's kind of got the benefit of an LLC without being an LLC, right? It's not public. It's not recorded. Nobody knows who the beneficiaries are. So that's the other thing. If you convey property into a Florida land trust and use those discretion tools, an entity in a state that's not very public, doesn't let you know who the owners are, you don't have a recorded trust instrument. If you're in a car accident, they're going to have absolutely zero idea that you have anything to do with land trust A or B or C or anything like that. So it really makes it challenging for a judgment creditor attorney to try to pursue assets that they don't know that you have any interest in.
Well, it seems like the analysis for an investor really comes down to, especially if you're only dealing with land, LLC versus land trust, right? I mean, if you're getting the asset protection in both cases, that's really what it boils down to. And it sounds like, correct me if I'm wrong, but it sounds like there's maybe less formalities, and there's going to be formalities, but what is the analysis in your mind that goes into LLC versus land trust when you're just dealing with real estate at that point?
So I think LLC, again, has its place if it's depending on the kind of investment. So for example, if you are a flipper, you fix and flip, I would not use Florida land trust. For me, Florida land trusts are more for long-term holdings. If you're regularly moving assets, and a limited liability company is just going to make more sense, right? Because it's like you've got the proceeds from the sale of this, and then you bought to sell this, and then you flipped, So if it's anything like that, I would say limited liability company or an entity is more what I would lean forward to, versus very long-term holdings where you've got the risk of like slipping and falling and those kinds of long-term tenant issues that arise. That's where I'd lean in more to segregating individual rentals into Florida land trusts. Yeah.
Now, how do you incorporate, I would think it's got to be common with investors to also have have had done some estate planning. So they also have maybe their own family revocable living trust. Maybe it's
Mhm.
irrevocable. Likely it's a revocable living trust. How do you incorporate that as part of the land trust equation?
So you definitely want to make sure that whoever the beneficiaries of the land trust, whether it's one of your entities or it's you, right? You update that to reflect either you as trustee of your family trust. So that's naturally flowing in there, right? If something happens, boom, beneficiary is already you as trustee of your family trust. Or if it's one of your entities, make sure that your entities are not left out of your estate plan. Make sure that your shares have been assigned to your trust upon your passing. So those background things need to be done concurrently. If you do have a land trust already and it's held solely in your name, you need to make sure that those assignments are taken care of to reflect that now the beneficial interest owner is no longer you individually, but you as trustee of something or an entity if you choose an entity.
So talk to us about the process. Somebody listens to this and they think, wow, this sounds really cool. I didn't know that that we could do this or have asset protection in the form of a trust. They want to pursue that. What does the process look once they kind of retain you? What kind of documents are you going to be looking for, and kind of start to finish, what does that look like?
So obviously, the standard, like we need to prove your identity. So what we attorneys request when we've been retained by a client to make sure that they are who they say they are. Depending on the type of real estate that you're thinking of putting into the Florida Land Trust, right? If it needs to pass muster, if it's the state of Florida and it, for example, might violate SB 264. That was a law that was passed last year that's, in my opinion, a terrible law, but that limited what kind of foreign nationals could own real estate and property. So I do want to make sure that, you're not from Venezuela or China or any other prohibited countries and trying to acquire property here in Florida, because it's no longer allowed without very serious restrictions. And so let's say, barring all that, you pass all that. Then we look at, okay, who do you want to name as trustee? And we have a very easy to use form that our clients complete where they put in the information that they want. We then give them feedback on it, because depending on who they want as a beneficiary, there could be tax consequences or not. And once we've come to some clarity with respect to that and the consequences of who they've chosen as a trustee and as a beneficiary and as person with the power of direction, if they want somebody separate for that, then we create the instrument. It usually takes about a week to get the process done. It's not super intensive. We, of course, prepare the deeds, make sure they have that requisite magical language of the statute. And either our clients get notarized at our office, or if they have a local notary with them, we let them know exactly who needs to sign, what needs to be signed. We also provide them with the trust certification, because it makes it a little bit easier for providing that to title companies for closing.
Now, I know and maybe you've already addressed this, but I'm trying to wrap my head around the person with the power of direction. So that seems a lot to me like just the grantor, the settler. But what are cases where you see the grantor settler create the trust, but want that power of direction to be with some other party that's not the trustee, but it's not them? That's kind of sounds like what it's built for.
Mm-hmm. Yeah. So if I were going to make like a similar situation to kind of get an idea of how this power of direction thing works, you can have in both revocable and irrevocable trust instruments what we call a distributing trustee. Right. So a trustee, that's the one that's designated to actually make the distributions and separate that role from other roles, from the traditional trustee does like determination of principal and income and who the beneficiaries are and blah, 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 blah. And the distribution trustee is the one that actually gets to decide how those things are specifically distributed within the confines of an agreement. So the person that's appointed as having the power of direction under a Florida Land Trust Act is kind of the one that's given that magical yes or no with respect to, yes, you're going to sign this lease agreement. Yes, you're going to sign this sale purchase contract. or this refinance or anything else like that. So they have like that ultimate decision-making ability within the confines of the trust agreement. And it makes sense sometimes when you want to create that extra barrier or distinction, especially if you're a beneficiary, and saying, no, like, I don't have authority to do this myself. I'm just subject to whatever the management here says. I just take whatever money they give me. So you might want to do that by appointing a separate legal entity or appointing a professional fiduciary company to act in that respect. So it's for heightened asset protection purposes that you do so.
Yeah, you know what I almost kind of like about that is if you want a second layer of consideration, you're able to do that without the risk of two trustees running into a stalemate, right? That was always the risk that I never liked about, I want to name, the two people that I trust as trustees that are going to help do this. That way we're not relying on one person. Well, it's like, well, what happens if one of them, or what happens if they both see it differently and you can't make a decision? This way you kind of get two looks at it, two people looking at it, but an ultimate decision maker.
Yes, that's the ultimate decision maker. And with respect to the Florida Land Trust Act, the trustees are unique in that they don't really have much discretion. It's whatever the majority of beneficiaries tell you to do at that specific moment, or the holder of the power of direction. You as trustee are just the rubber stamper, the signer. Yes.
Yeah. So they've come into your office. You've just kind of walked us through what they're looking at and what you're going to require of the client to put this together. What kind of time frame is somebody looking at if I want to get this set up from start to finish? Assuming I'm on the ball with what you asked me to do.
Yes, assuming we're on the ball, it's usually a week. And that's because I just want to give them an opportunity to review what we've drafted. And I also want to give them an opportunity to review our little training videos that we have for the Florida Land Trust Act, which is kind of like just a quick reminder of do's and don'ts. It's not long. It's not long.
What are the execution formalities like? Is it similar to a will? Is it they require witnesses, so on and so forth? What does the statute require?
Yes. So you have to comply with the statute in the same way as any other trust vehicle in the state of Florida, because the Florida Land Trust can be an estate planning vehicle. And in fact, the Florida Land Trust Act does make specific reference to if you want to put your homestead under a Florida land trust, it retaining the character and qualities for you to have all the benefits of homestead. Here would be the creditor protection, the protection with respect to devises, and the protection with respect to taxes and tax assessments. So there is that aspect of it. It's kind of seen as both a business tool and a personal quickie asset protection tool. But you do need to have two witnesses. They do need to be individual. It does, it should be notarized. It should have a self-proving affidavit, unless you want to have to bring in witnesses to court. So it should meet all the formalities of a will. Mm-hmm.
Talk to us about, given that you've set out formalities, the process, and the time it takes. What are the biggest mistakes you see people make in doing a Florida land trust?
So the number one mistake that I see is that people that try to do it themselves and have never in their life had a corresponding land trust agreement. They just have a deed. It says, oh, I got this as my land trust. I'm like, okay, where's your trust? So they never created it, never complied with it. And by default, if you conveyed it to a trustee on behalf of a land trust that doesn't exist, you've conveyed title and fee simple to that trustee. That trustee owns it all. No limits, no cap. So that's the biggest mistake that I see. Other mistakes that I think happen are, people convey it to themselves as trustees. So you don't really get that confidentiality aspect that you would if you conveyed it over to an entity acting as trustee. But there are certain times where you might want to convey it to yourself, especially if you want to maintain a trigger happy lender you know, to stay pleasant. It's like, no, I'm conveying it to an asset protection, but also estate planning vehicle. So that's why I'm conveying it. I have the protection of Garn St. Germain. I'm still the trustee. I'm still in control. So sometimes it's necessary to put yourself as a trustee of one of these. But really, the biggest mistake is the fact that they've never read the Florida Land Trust Act and don't realize that it needs a written instrument.
Yeah, I was going to say, so you had mentioned before, and you just said it now, the law requires that it be in writing. For somebody who just misses the boat and doesn't do it in writing, conveys it to the trustee, at that point, to fix that, are they just at the whim of the trustee's willingness to convey it back to fix it?
Yes.
Absent litigation, I guess that's what you're up against.
Absent litigation, that's what happens. So that's why it's so essential to have both in place, right? You want the instrument that is the actual Florida Land Trust to be done concurrently with the actual deed of conveyance so that it's effective. And let's say you're buying property as a land trust trustee. You want to have that land trust in place before everything gets executed, before the closing takes place, so that whomever you're giving title to as trustee is just receiving title as trustee and not in fee simple totality.
Now, does the statute provide any sort of wind down or termination process if an investor gets to the point where they dispose of the real estate, the land trust, maybe they're not going to do anymore and they don't need it? Is it necessary to wind it down when you're not using it any further? What does that look like?
So with respect to termination of the land trust, it's fairly simple. If you dispose of the asset, it's no longer there and it is considered closed out. So it's not too complex. It doesn't fail to meet any specific formality just because it didn't include like a termination provision, although it should. I think it's more important to have succession provisions in place. And here's the reason why, right? If you don't put in successor trustees, especially if your trustees are human beings, then you might have to, when there's an appointment of a successor trustee, actually disclose who the beneficiaries are, because it requires recording a succession by an appointment created by the beneficiaries. So their names become public. So you always want to have provisions for succession within the instrument, because if they are, then the Florida Land Trust Act respects that, and the appointment of a successor trustee in the public records does not have to indicate or show any of the beneficiaries. So that's another big mistake, is when they just put in one trustee and never a successor. It's like you just open the door to becoming publicly known.
Now, we've discussed with you in detail. In fact, we had an entire show designated to the Corporate Transparency Act with you. Is a Florida Land Trust at all invoked, or I should say, is the Corporate Transparency Act invoked at all as a result of forming a Florida Land Trust?
So not yet. We know, right, there's several legal challenges right now to whether the Corporate Transparency Act is even constitutionally allowed, or whether Congress passed muster in the way that they approached it. We'll see how that goes. But I know that there was a open rule period earlier this year in which many of us estate planning attorneys gave our feedback with respect to trusts being added as parties that had to disclose beneficial interests. On the one hand, right, because it's like, well, if it's a revocable instrument, there really are no other beneficiaries than the grantor, for the most part, right? It's like you
Right.
hold control. That's it. Florida land trusts are unique in that the grantor doesn't have to be the beneficiary, even if it's a revocable instrument. So they might be susceptible to the Corporate Transparency Act in the future. Right now, the Corporate Transparency Act does not include traditional trust vehicles to be reporting entities, but it is something that they want to become reporting entities, at least for now, right? They're not mandatory at the moment. I don't want them to become that. I want them to listen to all of us estate planning attorneys that put in our feedback and said, this is ridiculous. This is going to be so ridiculously onerous for everybody involved. And it just doesn't make sense if it's revocable instruments. There's no completed gift, as we call it, right?
Right.
Mhm.
Right. Well, we'll all put on our seatbelts and see how the Corporate Transparency Act ultimately fleshes itself out. Natalia, thanks so much for being with us. Tell our listeners how they can find and connect with you.
Sure. All right. So you can find our website at www.lcolawfl.com. You can also contact my office at 813-480-2106. And if you prefer email, like I do, you can email clientcare@lcolawfl.com. And then look out for that fun book, which I also wanted to add in a bit of nerddom. So I've mentioned before, right, that I'm doing the specialization in tax law right now at UF. And one of the requirements is to write a seminar paper. So I'm going to be writing mine on the tax consequences of creative financing. So that'll be something fun to talk about later.
Very cool. Yeah.
Yeah, that
That's good.
yeah, sounds like a must read. Good information, everybody. Natalia, thanks so much for being with us. We appreciate it. Let's do it again.
Thank you, gentlemen. It was lovely to see you guys again.
You too. All right, with everybody, that is our show. Make sure to join us for the Creative Finance Collective and every Tuesday at 10 a.m. for the NREM podcast. We'll see you next week.
Have a good day, everyone.